I'm thrilled to be joined today by two esteemed colleagues in the field who have paved the way for the Courtroom Animal Advocate Programs, or CAAP, as we've referred to them. Thanks to their pioneering work, CAAP programs have already been enacted in 2 states, Connecticut and Maine. And here at the Animal Legal Defense Fund, we are actively working to advance legislation in several other states to replicate these programs. Joining us today are Professor Jessica Rubin and Tara Cooley. Jessica Rubin is the Associate Dean for Experiential Education, Clinical Professor of Law, and the Director of the Animal Law Clinic at the UConn Law School. She was instrumental in creating Desmond's Law, which allows Connecticut courts to appoint advocates, law students under supervision in animal cruelty cases. She created UConn Law School's Animal Law Clinic, a clinic through which students appear in state courts as advocates under Desmond's Law. Professor Rubin actively supervises students and appears in court to advocate for justice in cases of animal cruelty. She is widely regarded as an expert in the field of animal law and is a graduate of Cornell University and Cornell Law School. Tara Cooley is the teaching fellow in the Animal Law Clinic at the University of Connecticut School of Law, where law students advocate animal cruelty cases under Desmond's Law, the nation's first courtroom animal advocate program law. She earned her JD from Golden Gate University and her LLM in animal law at Lewis and Clark Law School, where she served as an associate editor of the Animal Law Review. Cooley served as a legal extern at East Bay Community Law Center, a law clinic of the University of California, Berkeley, and the Health and Welfare Practice, where she assisted with community access to public benefits. For more information about our speakers, you can read their full bios on the website. Thank you so much for joining us today, Jessica and Tara. I'll turn it over to you.
Thank you so much, Kim, and thank you to ALDF for hosting this wonderful animal law symposium. Whether you're watching live or watching a recording, Tara and I are really excited to have an opportunity to speak with you today and share our experiences from Connecticut regarding the first Courtroom Animal Advocate Program. So as Kim mentioned, Tara and I both run the Animal Law Clinic at UConn's Law School, and our clinic is predominantly dedicated to staffing cases under Connecticut's CAAP law. And we've done a study and are about to publish the results any moment now, sharing those results, but we're excited today to have a chance to share our experiences a little bit more generally with you. But much of what we present today will be reflected in that article. And we want to start out by talking to you about CAAPs and the various forms that they can take and the roles of advocates appointed under either a CAAP law or a CAAP program. So to start, what is a CAAP? As Kim said in her introduction, it's a Courtroom Animal Advocate Program. In Connecticut, our CAAP is based on a statute, 54-86N, which was enacted in May of 2016 and went into effect in October of 2016. Colloquially, our CAAP is called Desmond's Law, and it's named after the victim of an animal cruelty case. So before we talk about Connecticut's CAAP law, we wanted to take a moment to really thank and acknowledge the other forms of CAAPs that have gone before us. Specifically, a CAAP can exist through an agreement between a bar association and a court. So in Onondaga County, New York, the VALAC program is really a CAAP model based on an agreement between the Onondaga County Bar Association and its courts. Similarly, and even prior to VALAC, the really first CAAP that existed was by virtue of a court order in the Michael Vick dogfighting case. The court ordered Professor Rebecca Huss to really serve as an advocate for the animal victims and to determine the ideal outcome for each animal victim of that case. So we thank those models and try to build on them. So as we said, Connecticut has a CAAP law, Desmond's Law, and Desmond's Law allows, it doesn't require, but it allows courts in animal cruelty cases to appoint advocates. And there are 3 key features, I think, about the law. The first is the advocate's role is to advocate for justice. So the advocate does not technically represent the animal victim, but instead is there to advocate for a just outcome. The second feature of the law that I want to highlight is that, unfortunately, right now in Connecticut, the law is restricted to cases involving dog or cat victims. Right? So it allows for appointment of advocate in any case involving a dog or cat victim. The third feature of the law is that it defines who could serve as an advocate, and volunteer lawyers and supervised law students under our practice rules are allowed to serve as advocates. Connecticut is, as Kim said, the first state to have a CAAP law and therefore a CAAP program. And so we wanted to take a minute to describe to you how we really envision the advocate's role. So the advocate can do a few things in a case. The first is the advocate can provide the court with supplemental information, and that information can be factual information or it could be legal information. So examples of factual information that an advocate might provide would be additional information from veterinarians or forensic experts. Examples of legal information that an advocate might provide would include things like legal research on a novel issue that arises in a case, right, that the court is struggling to decide. Other legal information that an advocate can supply includes how other courts within our state have resolved similar cases, right, to help inform the current court's decision. So the first thing that an advocate can do is provide that extra factual and legal information. The second thing that an advocate can do is to provide goods or services in cases where the human-animal bond should be maintained, but needs some help, right? So things like dog training or fencing, those kind of things have been helpful for an advocate to bring into a case to allow a human, where appropriate, to maintain their animal companion. The third thing that an advocate does in a case is give voice to the animal victim's experience. The advocate can present to the court what the animal might have experienced, and this is often informed by veterinary or other expert information. Ultimately, the goal of the advocate, as we see it, is to facilitate the court reaching a just, nuanced, and fair outcome in an animal cruelty case. Before we get into specific data, we wanted to provide you with some preliminary kind of overview data of how the law seems to be working in our state. Very encouraging statistics. Advocates have been appointed in over 200 cases since 2016 when the law was enacted. Second, every court in our state, so 20 courts, have used an advocate in at least one case. So we're everywhere. And third, we have approximately 20 volunteer advocates serving under the law. So all of those are encouraging statistics for us. So given that background, we wanted to explain to you or introduce to you how we approached this study of our CAAP law. So we thought it was an appropriate time, a few years into the law, to begin to look at, how it's operating and what, if any, case outcomes seem to be associated with advocates in cases. So the first part of our study involved a qualitative inquiry, where we tried to collect people's perceptions and opinions about the law. We did this by creating a survey, and we wanted to distribute it broadly. We got a very, very low response rate, the bulk of which were responses from prosecutors. We had 16 responses from prosecutors, only 9 of whom had experience with animal cruelty cases in which advocates were appointed. So we had a very, very small sample size, insufficient, in our opinion, to generate any meaningful takeaways on the qualitative side. Turning to the quantitative inquiry, we requested access to judicial case files in animal cruelty cases 2 years before and 2 years after the enactment of Desmond's law. We asked for access to all animal cruelty cases. And our goal here was to compare case features in cases that had advocates with case features in cases that could have had advocates but didn't have advocates. And those cases we're calling non-advocate cases compared to advocate cases. And if you're wondering why the non-advocate cases were included, so that's sort of our reference point or control group, and those cases were included because they were pending as of the date of Desmond's Law enactment, so they were open, and they involved a dog and cat or cat victim. So that makes them eligible for an advocate, but there were cases in which courts did not appoint advocates. So that was our quantitative inquiry. And we added another layer to that in order to get more information. And we looked at those cases that appointed UConn as the advocate. So we really had three groups of cases: the judicial case files with advocates, judicial case files without advocates, and then UConn case files, all of which involved advocates, because those are our cases. So you'll see in the ensuing slides that we compare judicial advocate cases with judicial non-advocate cases with statistical analyses, but we never compare the judicial cases with the UConn cases because they're different data sets and we're subject to different data collection methods. So we'll show you all three groups, but our analyses are based on just the comparison of the two groups of judicial case files. And so you can see here, we started with a very robust group of cases, 693, of which 246 were pending when the law was enacted and involved a dog or cat. And it's important, to understand that an advocate can be appointed at any point in a case. So that's why we just didn't say cases that started after Desmond's Law, but we said cases that were pending after Desmond's Law. So of those 246, 189 did not have advocates and 58 had advocates. In case you're wondering why those numbers don't add up, there was actually one outlier case that had an advocate but did not involve dogs and cats. So those are our data sets. And some of the things that we looked at in cases, in identifying case outcomes, we really tried to look at particular case features. So some things we looked at were type of charges, duration of case, type of animal, diversionary programs, which Tara will talk about in a few minutes, whether the defendant was convicted, whether there was incarceration ordered, whether the animal victim was surrendered. So we really tried to tease out particular case outcome features and answer those kind of questions. So on the next slide, we'll show you how advocate appointments are trending. And so the first graph is, again, just the judicial case files, which stop at 2019 because that was the end of our inquiry. The UConn case files, again, continue because those are our case files. And you can see, with the exception of the pandemic year of 2020, it's a very encouraging trend here. 2022, you'll see, is included throughout the end of the year, but our article only goes through half of 2022. So in total, UConn has been appointed to date in 109 cases. As I said, other advocates and UConn have been appointed in a total of 200. More important than the statistics to me has been our personal experience, which is that in the early years of the statute, right, in 2016, 17, 18, even 2019, we were writing to courts to request appointment in cases. We no longer do that, right? We are appointed on the court's initiative, and we get phone calls, we get emails informing us that we're appointed. So I think our personal experiences are more compelling than the statistics to show us that the program is really established in our courts, and our judges and prosecutors and even sometimes defense counsel are turning to us. So again, very encouraging trend on this slide. And I think our personal experience just really illustrates that.
Great, and thanks to everyone again for joining us. That's really cool to see everyone joining from all over. So Jessica and I selected a few categories from our article to present today. So we're not presenting all of them. For each category, as Jessica mentioned, we're comparing two judicial groups. So the judicial cases in which an advocate was not appointed to the cases in which an advocate was appointed. And then separately, although we're going to show it on the same slide, there are the Yukon case files. And again, there's no non-advocate cases for the Yukon cases. They're all advocate cases. And the Yukon Animal Law Clinic was the advocate in all of those cases. On this slide, looking at convictions, all three groups have similar rates of conviction. The cases included here are resolved cases only, which means that we excluded any cases that were pending at the time of the study. So for example, there were 88 cases that we included from the Yukon case files in the study, but 74 were resolved and 14 were pending at the time of the study. So we're excluding 14. In Connecticut, once the state decides to prosecute a case and the case is docketed, at that point is when an advocate could be appointed. But just because the case has been docketed does not mean that it will always lead to a conviction. The state may decide at some point to no longer prosecute the defendant for that charge, and the case will eventually be dismissed. Or alternatively, a defendant may successfully complete a diversionary program, which we'll talk about those in a second. And if they successfully complete it, then that case would also eventually be dismissed. If the defendant is convicted, that doesn't mean that they will actually serve any time in jail, that they will be monitored by probation, or that they'll have any specific conditions attached to that conviction. The court has the discretion to determine all of those things on a case-by-case basis. So what impact may the advocate have on convictions? In my experience, if the court appoints an advocate, it typically means that the state does not expect the case to be resolved that day, or maybe even the next court date. And the court or the party, whoever requested that we be appointed, they likely think that the advocate can assist in some way in the resolution of the case. We're less likely to be appointed in a case when the parties have already determined that the case is likely to be dismissed. Once an advocate is appointed, the advocate can make a recommendation that the case be dropped, that a program should be granted, or if those are found to be too serious, that the defendant be convicted for the charge. The advocate's position may have an impact on the position by the state or the court. Sometimes a plea offer or that the decision that the state is going to go forward with a conviction is already made before we're even appointed. So the advocate's potential impact really depends on when the advocate's appointed and procedurally where the case is at the time of that appointment. So for incarcerations, so if a defendant is convicted, their sentence may include a period of incarceration. The cases included here are only cases in which the defendant was convicted. The case was marked as yes if the sentence included any period of incarceration, whether or not the defendant actually served any time in jail. So for example, in some misdemeanor animal cruelty cases, the defendant may be ordered to serve 364 days, which is the maximum time permitted in Connecticut for animal cruelty, but the sentence may be and often is fully suspended. As long as they comply with the conditions of probation. So for example, it might be that they can't be arrested on a new charge, then they will not actually serve any of that time. In the judicial non-advocate cases, the sentence was fully suspended in 45 of the 74 incarceration cases. So top left, there's 83 cases, 74 of those, there was incarceration included in that conviction case, and then 45 of those were fully suspended, or 61%. In the judicial advocate cases, the sentence was fully suspended in 14 of 19 cases, which is 74%. For Yukon, the sentence was fully suspended in 24 of 31 cases, which is 77%. Like the conviction rates, these three groups show similar rates of incarceration. Advocates may be invited to join judicial pretrial conferences in which the case is discussed between parties and the judge off the record. This is often where the plea deal is discussed and negotiated, including what and if any conditions will be attached to probation. The advocate is unique in that we may have a broader understanding of what is standard in animal cruelty cases. So for example, the advocate may go to courts and attend animal cruelty cases all over the state. So for example, for me, I've been to at least 14 different courts and have been appointed, or UConn's been appointed in cases with over 20 different judges that have been involved with those cases. And prosecutors, they may only be familiar with their court or maybe one other court. Defense attorneys, they usually are regional, so they may be appointed, or they may take cases in like 3 to 4 or 5, maybe different courts. So the advocate can present related precedent and inform the parties and the court to ensure a fair and consistent outcome. This information can also help to facilitate conversations between judges, specifically about diversionary programs, which can be especially difficult for courts to make decisions on. Okay, so for granted diversionary programs, in Connecticut, statutory diversionary programs are available to qualifying defendants as an opportunity to avoid a conviction. For example, for family violence or substance abuse related cases, there are specific programs and services available to those defendants. There are 2 programs that are typically used in animal cruelty cases in Connecticut: the Accelerated Rehabilitation Program, or AR, or the Supervised Diversionary Program. So to grant AR, for example, the judge must determine that the conduct is not so serious to deny the program and that the defendant is not likely to reoffend. If the judge grants the program, it can be granted for up to 2 years. The judge can order certain conditions or services that the defendant must participate in to successfully complete the program. For example, it could be completing therapy, educational classes, paying restitution, or restrictions on certain types of conduct. If the period of the program expires and the defendant has complied with all of those conditions, then the charges can be dismissed. If the defendant fails to comply with the condition of the program, then the court can terminate the program and the defendant may once again be prosecuted on those charges. If the court denies the program, then the prosecution of the defendant will continue. Here we are looking at the cases in which a defendant applied for a program. So they don't always apply. Sometimes they're not eligible. Sometimes they may choose not to. There are similar rates of granted programs in the judicial cases and a lower rate of granted programs in the UConn cases. The advocate's support or opposition of a program depends on each individual case. While an advocate may focus on the seriousness of the conduct and the impact on the animal victim, there are other non-victim related considerations that may lead a court to grant a program when the advocate opposed. The court takes into consideration the position of the state, the defense attorney, and the advocate in making the decision related to a diversionary program.
So probation. So when a defendant is convicted of animal cruelty, the court has an opportunity, if it chooses, to include in that sentence an imposition of probation conditions. If the sentence includes probation, the defendant is then assigned to a probation officer whose job it is to ensure that the defendant complies with the court's ordered conditions during the probationary period. And just for an example, for misdemeanors in Connecticut, the probationary period usually ranges from between 1 to 3 years. So probation can include some of the same conditions that Tara described as connected to diversionary programs. So probation conditions could include things like ordering a defendant to pay restitution, to seek counseling, to engage in educational programming, to perform community service, to relinquish firearms, to avoid contact with particular individual people, to avoid new arrests, and or of most important in our cases is to refrain from contact or ownership of further animals. So on this slide, we're looking at only cases that end with convictions, because those are the only cases in which probation could be ordered. And we see a significant association between advocate use and courts ordering probation. While the Yukon cases have a higher rate of probation than the non-advocate cases, the advocate cases in the judicial files have an even higher rate of probation being ordered. So it's really important to recognize that an advocate can really assist a court in ordering conditions that are specific to each case and that are individualized to the needs of a defendant and the animal victims and other potential animal victims. So it's really an opportunity for the advocate to focus the court in on needs and help the court craft conditions that address those needs.
So an example of a condition that could be attached to a program or probation is contact restrictions or the defendant's ability to have contact with an animal. There are typically two times during a case when this may happen. So first, a court may order a restriction on the defendant's contact with animals as a condition of release. So that just means while the case is pending. This is typically ordered at arraignment or hopefully ordered at arraignment. If a judge appoints an advocate at arraignment, it typically means that the judge is familiar with the advocate program and likely familiar with a request that we would make. So it's typically more likely that if we're appointed at arraignment, that there will also be a condition of release restricting the defendant's contact with animals even before we actually appear in court. If not ordered at arraignment, the request can be made at any point during the case while the case is pending, if appropriate to the case. And this is typically the first thing that an advocate would do when they're appointed. Examples of these types of restrictions are no contact with animals, no unsupervised contact, no ownership, possession, caretaking, responsibility, or living with animals. And this not only usually includes the victim animal, but it would include animals broadly. In addition, although separate from the restriction on contact, the advocate may ask that the defendant submit to wellness checks by an animal control officer to check on the well-being of animals, including the victim animal, and in more serious cases may request that the defendant temporarily surrender the victim animal while the case is pending. Those two things I just mentioned are not what we would consider restrictions on contact, and we are not included in this study. A second time in which the court may order the restriction on contact with animals is as a part of the resolution of the case. So as we were talking about with diversionary programs and like Jessica talked about with probation, that would be another time where they may make that restriction as part of that case resolution. So for example, if a program is granted or if the defendant is convicted, so even if it says sometimes there's something called a conditional discharge, that's also, it's similar to probation. It's a conviction and they still have conditions attached, but they're just not monitored by probation. So any of those three things would fit into this pie chart on the right. So on this slide, we're only showing Yukon, and we'll get to the judicial information in a second. So for the Yukon cases, we were able to divide the contact restrictions between these two categories and present it separately. So what the actual order is and how broad the restriction is. So for example, no contact with any animals is more restricting than no new ownership of a companion animal. So that type of order may differ and depend on if it's a condition of release or if it's an order that's attached to a resolution. So sentencing courts may be more concerned about narrowly tailoring the condition at the resolution of the case, and they're typically more familiar with the case and the facts at that point than at pretrial, at the beginning of the case and at arraignment. Interestingly, though, while the actual restrictions may differ from condition of release and then resolution, the rates of the ordering of those restrictions were exactly the same in comparing conditions of release and program and probation restrictions. So now looking at the judicial, so when we started collecting the judicial data, we only had one question about contact restrictions. So yes or no. So it's unclear in each case if the court ordered a restriction as a condition of release, or as we were talking about with the Yukon cases, as a condition of probation or program. So therefore, for the judicial cases, we're showing it whether there was any restriction or contact at any point in the case. So if it's a no, then the court did not order a restriction on the defendant's contact at any point, not as a condition of release, not as part of a program, not as part of probation or a conditional discharge. Here, there was a significant association between advocate use and the ordering of contact restrictions. In future studies, it will be interesting to look further at how these orders change based on the case and when the request is made. Another thing that we have been focusing on is monitoring these requests. So because we're increasingly making these requests, and officers are unfamiliar with them and unsure of how to monitor them. So for example, it may be unclear what the officer can and cannot do, and also just getting that information, like what the order was, being able to get that to the officer so that they have that available to them. If they don't know what it is and what they can do, they may be less comfortable to act. The advocate can assist in these situations by discussing the orders with the town attorney so that they can advise their officers. The effectiveness of these orders depends on the ability of towns to follow up and document violations.
So one of the most important things I think that fall within the advocate's responsibility is to provide immediate assistance to animal victims. So Tara and I teach our clinic students, like the first question when they get a case is, where's the animal? And the advocate really serves as the liaison between the court and law enforcement and the investigating and animal care team. So we can provide that channel of information. We've seen that often, and I'm sure this is not news to many of you who practice in this area, often for no other reason than for a lack of communication about the animal victim. Animals are often left in shelters in temporary custody while a case drags on. And so they can't go back to the defendant and they can't be rehomed. And we saw during the pandemic that this period of time sometimes stretched for over a year or sometimes 2 years. So in a case, an advocate can really inform the court and all parties about the condition of the animal and their costs of care, and to help to facilitate a final outcome for the animal as soon as possible, often long before the case is resolved. So that's been some of our most impactful and frankly, personally gratifying work. There are, of course, some situations where surrender of an animal is not possible. For example, if the animal is deceased or if the animal is owned by somebody other than the defendant. But surrender is one area of our work where I think the advocates are especially effective. And you can see on this case, on this slide, that in over half of Yukon's cases, we were able to facilitate the surrender of the animal victim. I want to emphasize that as a general matter, our clinic does not have a uniform approach to these cases on the specific issue of animal surrender and on all the other issues that Tara was talking about. So we don't have a position that we always take, for example, regarding defendants' applications for diversionary programs. As Tara said, we look specifically at the facts of each case in order to formulate our recommendation. And that's really excellent work for law students. And so on the surrender issue, the advocate does not always recommend a surrender. There are many cases that we've had in which the defendant simply needed some resources, some training, education, or some other type of support in order to allow their animal to remain with them and receive proper care. So moving on and zooming out from the statistics, we wanted to take a few minutes to reflect with you on some of the challenges that we see that we faced in this study. So some of them are theoretical and some are very practical, and I just want to talk through them with you. So on the more theoretical side, it's difficult to define and assess what a successful outcome of a case is, especially in terms of an animal cruelty case, right? There are varied ways to define it. Do we define success as deterrence from future offenses, maybe by public outcomes of these cases? Do we define it by rehabilitation of the offender through education and counseling? Do we define it by punishment of the offender? Do we define it by incapacitation of the offender by saying you can't have contact with animals? Do we define success as being able to maintain the human-animal bond? Or do we define success as the rehabilitation of the victim animal through surrender, care, and rehoming? So there are a lot of ways to look at and define success in an animal cruelty case. And rather than having a yes/no answer, what we tried to do instead was dissect all the different features of a case outcome and study those. Another more theoretical challenge was isolating the impact of an advocate. In any criminal case or civil case, it's very difficult to isolate impact of one feature. And so in animal cruelty cases, it's difficult because one could say that certain cases are more likely to have advocates, right? Is it more serious cases, or is it judges who have used advocates in the past? So there are a lot of contributing factors. And so rather than trying to isolate and make a claim as to the advocate's impact, what Tara and I tried to do instead is describe associations that we observed, right? What we see happening in cases, rather than making a claim that the advocate is causing some impact. A second group of challenges that we faced was the timing of the study and whether or not we conducted it too soon in the life of the law, right? Before people maybe knew enough about the law to respond to our qualitative survey, or perhaps too soon because there weren't enough cases to generate a gigantic set of data to study. A third challenge that we faced was a lack of information in case files, right? We were unable to find information in every case file to answer every question. So where information was missing in a case file, we had to exclude that case from the study of that particular question. So we had a lot of exclusions. And looking forward to sort of address this problem of documentation in court files, in our article in the Appendix C, we suggest a standard court form to be used in all animal cruelty cases that will both generate better data for future studies, but also prompt courts to think about various things that they could do in animal cruelty cases. For example, appointing an advocate or ordering no contact. So we hope that Appendix C will be helpful moving forward. A final group of delays, of course, relates to the pandemic. And this impacted our work in two different ways. The first is that it delayed and interrupted our collection of data many, many times. As courts closed during the pandemic, so too did our data collection efforts. And so, what could have been and should have been a shorter study close to the law's enactment date ended up being very, very extended. And so now we have, a long look back period. And as Tara said earlier, what we're doing today in terms of our advocacy may not be reflected in all of the data. The second impact of the pandemic was really that it interrupted and elongated the duration of cases. So we had in Connecticut a couple of rounds of delays, and they were quite long. So when we tried to measure case duration, it's very difficult to pull out the delays from COVID and how they impact case duration. So those are some of the challenges that we faced in the study. And I'll let Tara share with you some general observations.
So while Connecticut's CAAP is still new, it appears courts are using advocates at an increased rate. In Connecticut, judges rotate each year, and as they rotate, so does the use of advocates. So that means each year, new court personnel, new attorneys are becoming familiar with the advocate program. And that not only increases the number of appointments, but it's also increasing the number of volunteer attorneys that we have serving as advocates. So just as an example, just this past summer, right after a new judge was appointed, it was probably in their first week. It was the first animal cruelty case of the day. And the judge said, isn't there supposed to be an animal person, someone here? And we were very excited to hear that, a new judge was already aware of who we were. So luckily there was an appointed advocate, and we were able to say, yeah, that's us. But at the same court, when there was a more experienced judge who was filling in, they were not as familiar with the advocate program. So it just depends. And there's certainly still a need for education and outreach related to the program. So here are some summary observations, but keep in mind that this judicial data from the early years likely does not adequately reflect the current advocacy under the law. So as we stated above, there does not appear to be an association between advocate appointments and rates of convictions and incarceration. An advocate's recommendation, as we've said, varies by case. We may recommend that the case be dismissed, that a program be granted, or that the defendant be convicted. And it all depends on the facts and circumstances surrounding each individual case. There was an association between the use of advocates and probation. I personally think this is interesting because typically, even before we are appointed, if there is an offer made, it usually, and it's usually a misdemeanor charge, it usually includes at least some time of probation. In some situations, the advocate may recommend a conditional discharge instead of probation, which I think can come to one of the enforcement questions that I saw. And especially if the defendant has already complied with certain things before sentencing. So for example, if they've already paid restitution in full, we may request that the court order, conditions attached to the conviction, but not that they need to be monitored by probation. It may be more difficult to arrange the early completion of certain conditions without the assistance of an advocate. And it is possible that just the appointment of an advocate in itself, without any input from us or even our appearance, may lead prosecutors to feel more pressure to include probation when they otherwise may not have. The rates of granted diversionary programs did appear to be lower in advocate cases, but there was not a significant association. Diversionary programs are difficult to review because the standards for these programs leave significant room for interpretation and judicial discretion. From my experience, there seems to be less consistency from case to case on whether a program is granted or not, in comparison to whether there's a conviction or not, or conditions, whether there are conditions attached. The outcome may depend on not only the judge who's hearing the case, but also the individual prosecutor, the defense attorney, and the advocate that's appointed on that case. As advocates collaborate and provide more consistency in their advocacy related to all cases, but related to diversionary programs specifically, this could lead to more consistent outcomes across the state. Advocates may assist in determining appropriate conditions to attach to a program, probation, or assist prosecutors in determining requests that the defendant should complete before a case is dismissed. So we may agree that this case could be dismissed, but we want them to do an educational course or put up a fence or do something like that before it's dismissed. there was an association between advocate use and court-ordered restrictions on the defendant's contact with animals. And while there was no association related to restitution, which I know we didn't have a slide for that, there was a slight increase in court's ordering of restitution, which typically is reimbursing the town for medical costs and costs of care. So last, the advocate may have a significant impact on the animal victim's experience. While these aspects of the advocate's work often occur outside of the court, off the record, and it can be difficult to see. Advocates can expedite an animal's rehoming, facilitate reimbursement for costs of care, suggest needed resources for pet owners that can improve the lives of the animal victims and other animals that are in contact with the defendant. Advocates collaborate with rescues, nonprofits, animal control officers, town attorneys, court personnel, and various other individuals and organizations to improve the services available to companion animals and their families. As use increases, it becomes even more important to improve data tracking efforts so we can provide accurate information to courts, the community, and other jurisdictions that are seeking to implement similar programs.
So looking forward, it's our hope that CAAP laws and CAAPs in general can help courts come up with, arrive at case outcomes that are fair and that are tailored and that are just. It's also our hope that within Connecticut, our program continues to grow, and growth would be more appointments, and growth would also be consistent best practices among our advocates within our state. Of course, even when we do have involvement in a case and courts order restrictions on defendants, that those restrictions are subject to enforcement, right? And so we rely heavily on probation officers and our animal control officers to enforce those orders. And both offices, both professions need support and resources in order to do that work. So we still have some work to do on that front with our partners on the enforcement side. And finally, it's our hope that CAAP laws proliferate across the country. And we think it's a great way to have advocacy in the courtroom and have meaningful impact on animal victims and cases. We also hope that within our state of Connecticut, even though we've made such wonderful progress, we have growth still in front of us. And we hope that our CAAP law has an opportunity to expand so that it applies to all animal cruelty cases rather than just those involving dogs and cats. And so with that, let me just clarify in response to one question that came in, that Desmond's law is really the colloquial name. The official statute is Connecticut General Statutes 54-86N. We don't have a name for it. And it's interesting that all of our courts call it something different, right? So some people call it, when we walk into court, they say, oh, you're the animal advocate, or you're the doggy GAL. And so the statute itself doesn't have a name. We call it our CAAP law and refer to it by its official statutory codification. So thank you, and we look forward to answering your questions.
Wonderful. Thank you, Tara and Jessica. I'm happy to open up to Q&A. We've got a good amount of time to discuss questions, which is great because we have a lot of them rolling in already. Before we do that, I was remiss in not introducing myself earlier. I was so excited to introduce Jessica and Tara, but my name is Kim Kelly. I'm the Director of Legislative Affairs at the Animal Legal Defense Fund, which is important because some of the questions talk about expanding the program to other states. So there might be opportunity for me to discuss that a bit during the Q&A. But I'll get us started with some of the early questions that came in. A number of them were addressed during the presentation, so I'll try to skip over those. But just to get us started, we have a number of law students joining us for the symposium, and I was hoping you could speak a bit more to what the law student role is within the CAAP program.
Sure, I can start with that, and then Jessica, feel free to jump in. I'll just start by explaining kind of what our clinic does and how our students are involved. And so we typically have 4 to 7 students at any time, and typically they'll have maybe 4 to 8 cases, and we typically will be appointed in 25 to 30 cases at a time. And so compared to, and I try to think about how this might compare to other clinical experiences. Typically you have more cases, so you have more opportunity to, review facts, to interview individuals who are involved, which could include, the officers who responded, potentially, in some cases, witnesses, or being able to talk to parties about it, being able to, for us at least, Jessica and I, being able to connect with town attorneys and things like that. So there's lots of opportunities for them outside of court to review sometimes hundreds of pages of veterinary records and interview veterinarians and things like that. So there's a lot of opportunities there. In court, the students get a lot of experience in court, and not just our animal cruelty cases. We don't have an animal abuse court in Connecticut, so we're viewing all criminal cases. So it's really a great opportunity for us to see what different courts are doing generally, and get to come back and talk about that and see some of the issues or some of the really great things that we've seen in different courts. On the record, students get amazing opportunities to speak, to provide substantive arguments, to, and not even on the record, just in court, they get to join judicial pretrial conferences. And Jessica and I try to let the students really just take control and get to have those, those unscheduled conversations. And that, I think, is the most rewarding experience for students, to not have something planned, but to have to go in and have a conversation with the judge and the parties in the case. And sometimes, often they'll be asked to, recite the facts and to really provide the background information for a case. They, of course, have additional opportunities to write letters and write, for example, maybe explaining to the judge the suffering of an animal. There's a lot of different opportunities that students get. Jessica, do you have anything you'd like to add?
Great.
Yeah, sounds like a lot of great opportunities and experience for the law students. The next question, is the role of the advocate similar to the role of a prosecutor or an animal control officer?
So I can answer this. No, I see the role as very different. It's actually a third lawyer in the courtroom, which is, very innovative, but we bring a different perspective from the prosecution. So the prosecution represents the state. We are there to address the animal's interests and the animal's needs. And we bring expertise, right? In Connecticut, our prosecutors, our defense lawyers, and our judges don't see a tremendous number of animal cruelty cases. So there's nobody who specializes in this area other than advocates. So we're able to bring a lot of information about the law, about past practices, and about resources, right? So when a court is looking to rehome an animal, or where a prosecutor wants to suggest a surrender, the advocate can be there to say, well, I've found an organization, or the ACO couldn't get time off to attend court today, but here is a text from, here's information from the ACO, so let me be of help here. So I think that the goal of the advocate is not the same as the prosecution. I think the advocate brings resources in terms of expertise and, frankly, time, right? Our students do a tremendous amount of factual and legal research that other parties in the case may not be able to do. And we can also access resources and organizations and personnel that often prosecutors may not have the ability or the time to do. We have great relationships with our animal control officers in our state. And so, the ability to reach them on a moment's notice when they're needed in court, and save them taking a whole day or 2 days off to sit through court continuances is really valuable to them. We appreciate how much work they put in investigating the cases. And frankly, the history has been that they've put in a tremendous investment of time and resources to prepare a case. And sometimes it goes nowhere. So we can be there every day, that the case is on, to ensure that that work does not fall by the wayside, and to ensure that our ACOs have, that their cases continue. So I see our role as very different. I see us as having expertise and resources that the prosecution, the defense don't have. And I see that as the value that we can add in cases.
Great, thanks, Jessica. A question that I'm particularly interested to hear your response, and I can add on as well. What is the legislative status of these programs? Are other states working on this?
So I can answer part of that question, and then Kim, I'll kick it back to you to answer it on behalf of ALDF. So, for me, the advice, a lot of people ask me, like, I'd like to do something similar in my state. What would you recommend? So for us in Connecticut, I just want to point out it took 3 times before our bill passed. And so patience was beneficial. The second thing that helped was that we had data from historical animal cruelty cases and how they were treated. Our legislative commissioner's office does a research report every year compiling data on animal cruelty case outcomes. And we were able to point to that, to show what's been happening in cases of very high rate of dismissals, over 80%. And that was very compelling. The third ingredient, I think, to success of legislation like this is to have a legislative champion who has credibility with the state legislature. We had that in former Representative Diana Rubin. She was able to really see this legislation through. The fourth thing I'll say is that I don't believe that it's necessary to have the collaboration of a state law school in order to make this kind of legislation pass. We were lucky to have that. And I think that it was a great signal to the legislature to say, the State University of Connecticut is on board, and we have this program teed up and ready to go, where we'll have a steady stream of advocates to volunteer. So this will work. So that was nice, but I don't think it's necessary. I think a CAAP can exist in states where there's not a law school partnering to make it happen. I think it can happen, like I said at the beginning, through agreements, through court orders. And so I think it's a really flexible tool. And I would just urge people who are out there considering it not to hang everything on having the collaboration with a law school. I don't think that's necessary. It's great, but not necessary.
Thanks, Jessica. And just to note, thanks to the work that you've undertaken in Connecticut and now the passage of the legislation in Maine, this is an issue that other states are considering. In recent years, we've been working on this legislation in New York, New Jersey, Florida, Illinois, Michigan, and a handful of others. As Jessica noted, it took 3 years to get this passed in Connecticut. And especially for novel types of issues like this one, it can take a little bit longer. Because this has passed in a couple of states now, some state legislatures are interested in learning more about the results, the effectiveness. So the study that you've undertaken, I think, will be really helpful as we work with legislators in other states. We have had the bill heard in a number of committees. It's been very favorable to date, and we're still in a place where we're working with like-minded organizations and other stakeholders to garner more support as we work on these bills. So there are a number of questions and comments from folks who are interested in working on a similar bill in your states, and we welcome the opportunity to partner with attorneys and law students out there and anyone who wants to work on these bills. So if I won't answer each of these directly in the Q&A, but please do get in touch. You're welcome to email me at kkelly@aldf.org, and I'll be happy to put you in touch with our legislative affairs manager in your state to see how we might be able to explore the possibility of the legislation where you are. Okay, moving on to the next one. How does the CAAP approach compare to different approaches that other jurisdictions use to address animal cruelty in their states?
Yeah, I can take this one, Jessica. So yeah, well, first, every jurisdiction is very unique. I think it's probably safe to say, though, that, wherever you are, that there are, resources or supports that could be implemented in some way. And, there's a variety of approaches. So there's special prosecution units, there's animal abuse court, there's special training that's available for, for animal control officers and individuals who are responding. There's also programs for communities to help provide resources and support to pet owners. And hopefully that leads to, a reduction in cruelty cases, for example, Pets for Life. And so I think these are all wonderful approaches. And what I'll say for our program is that we are able to really use it as an educational opportunity. So one thing that CAAPS does is, yes, we're appointed in one specific case and doing our best to advocate in that case, but at the same time, we're connecting with town attorneys and animal control officers and courts and providing them the resources that they need. So if we are not appointed, they have a lot more support and information so they can go forward and have more consistent outcomes. And I think that a lot of those things are happening in all of those different programs. But I will say that one unique thing about CAAPS is that, we are an attorney who is appointed in that case that's coming to court. We have the ability to speak on the record and to provide our position and recommendation. And just having us, the courts know us, they know we are the animal advocates, they, enjoy having us there. And it really means a lot to everyone in the court, including the public, to have someone up there that's speaking on behalf of the animals.
Thanks, Tara. The next question, did you look at demographic characteristics such as race and gender in your study?
So we did. Our study was not designed to really analyze those case features. And what we found was many of the court files were lacking that information. So rather than sort of rely on incomplete information or exclude a tremendous number of case files, our plan is that's sort of part 2 of our study. And so we'll look at that and write about that quickly and be able to share that information.
Thanks, Jessica. Combining a couple of questions here. Will you be able to share the results of this study for folks who are interested in obtaining stats? And are there any other additional journal articles on the subject of CAAP that might explore their impact aside from the materials that we've already included?
So the article will have all the stats, 60 pages of it. And like I said, we expect it to be out within the week. And it's been a long haul, but I think that has the statistics that people would want to see. I'm sorry, Kim, what was the second? Other readings. Yeah, I would refer to that. The first 2 things written about Desmond's Law were more sort of a plan for doing it in other states and sort of a guide to how we did it. The second thing was a initial reflection on how it's going. And so this is really the third piece of it, some statistical analyses looking at it. And I guess the fourth thing that Tara and I will look at, it's, the race and ethnicity data, and that'll be 4, and hopefully that'll be it. I know one of the questions asked about plans to expand this kind of program to civil cases, and I think it's a really interesting idea. It's something we talk a lot about in our clinic, in our class. I can say in Connecticut, I feel like we're both busy with what we have in front of us right now. So I can't speak to other people's thoughts about that, but right now that's not on my immediate radar.
And it's mentioned that it's interesting that you mentioned that, Jessica. As we talk about legislation in other states, one of the challenges is that, of course, every state is a little bit different, and legislators have their own unique spin on what they think an ideal CAAP law might look like. And so some of the things we have to work through is, should this just be applied to criminal cases, or should it be open to civil as well? Some of the other, just in case people are interested, some of the other things that we look at is how will this be administered? Should it be through the Bar Association or through the courts? And should it apply to just companion animals, or should it be applied to other animals as well? So as you're thinking about whether or not you want to work on this legislation in your states, these are some of the issues that might arise. I think for the next question, I think we might have touched on this already, especially with some of the more rudimentary type work that was done in CAAP before it was enacted in Connecticut. But someone asked a question about whether or not programs like this exist in other states.
So at the beginning, I mentioned the VALAC program and the court's order in the Michael Vick case. And then, what Tara described a few minutes ago, specialized courts, specialized prosecutors, are all, I don't want to say, are variations on this, programs by which somebody can advocate for an animal and look out for their interests. But to my knowledge, Connecticut is the only one that's actually implemented, as you said earlier, Kim. Maine has its own CAAP law. So now we've got 2 states, and we're eager to see how Maine implements it, and we're excited for them.
And I'll just add quickly more about the question about articles. So Rebecca Huss did publish an article, if any of you out there haven't read it yet, related to the work and their appointment and related to the Michael Vick case. So
great. So we have a couple of attorneys in states that have not yet enacted CAAP laws, and they're interested in becoming involved. Does Connecticut require an attorney to be in the state of Connecticut, or can the attorney be remote?
That's a really interesting question. Our criminal courts don't allow remote participation by lawyers right now. So, I don't know. I suppose it's also a very, very difficult thing, because a lot of what happens in our criminal courts is in the hallways, I would say, but as Tara said, conferences with judges, the actual in-court on the record arguments are, scheduled and formal, but there's a lot of other back channel work that happens in these cases. So I think it would be hard. Somebody would need to be admitted in our state to practice in our state. But our criminal courts are not set up right now for remote participation. Maybe they will in the future.
Great. And then actually this gets to something we were just chatting about, but does Desmond's law apply to animals other than dogs or cats? And do you see pros or cons either way to expanding it to other animals if it is limited?
So it's limited right now to only dogs and cats. That was a compromise that we made in the legislative process in order to get the bill through. And we just had a bill introduced this past session, this current session, actually, to expand it beyond dogs and cats to all animals. I don't see cons to that expansion other than the political hurdle of getting it through. I think it's something that should happen. I think it's really necessary. We see a lot of cases involving cruelty to other types of animals. I will say, though, that there's nothing preventing courts from appoint. We've served in cases where the victim was not a dog or cat. So, I think the statute should be passed. I see tremendous need for it, and I hope it happens.
Great. Okay, going back to the pie charts for a moment, there was a question as to whether or not there were actually fewer convictions when an advocate was involved, and I thought that perhaps that seems inaccurate or not what one would expect the results to be. Could one of you speak to that a bit further?
would it be helpful for me to share again quickly, or?
I think it's up to you, Tara. If it's easy to do so, wonderful. But if you just have the information, that would be fine as well.
Okay, I think I have it up there. So Jessica, did you want to jump in, or do you want me to just talk about this for?
Go for it.
So yeah, so as you can see, so the non-advocate is the cases where these were judicial cases where an advocate could have been appointed but was not. So there were 49% of those cases where the defendant was convicted, and 51% that is no. So, and then if we compare that, I think is what your question is. So it's 44% were convicted in the advocate cases, and 56% were not. And then Yukon is kind of in between that. And I think one thing I'll just say about, you know, for me personally as an advocate, my goal isn't to increase convictions, it's to increase the view and the seriousness that the court is looking at the case. And it really just depends on each individual case, right? So, and just some examples that I provided earlier, related to a situation where there wouldn't be a conviction. Often if it's, you know, the state isn't going to prosecute and it's going to be dismissed, often we won't be appointed in those cases because they've already agreed that, you know, for whatever reason that they're not going to. There have been some situations where we looked at it and felt, after talking to all the investigative officers and everyone involved, that you know, it should not go forward as a conviction. The diversionary programs are another. And even in those situations, often we'll recommend that there be services that are provided before the case is dismissed. So, you know, if there's an issue, if, for example, the animal keeps getting out and they're roaming and they're scaring the neighborhood, you know, maybe there are some fixes and things that we can do in these lower level cases to support the community, support the owner without there being a conviction. In diversionary programs, the goal is that we're providing and we're working on additional programs so we can provide resources for counseling, assessment, and treatment. And so those things are opportunities for us, again, to provide support, and it may not be appropriate, and we may not recommend a conviction. Jessica, I'll let you jump in if there's anything you wanted to add.
Yep, that's great. Thanks.
And we are short on time, so I'm going to try to combine a few questions, and then any that we don't get to, we can follow up with on email later. There are a number of questions about contact with animals and how that's enforced if they are prevented from having contact, whether or not the contact extends to other species. So, for example, farmed animals, if they're not permitted contact with the companion animal. And also if the defendant is required to pay the cost of care or bonding for the animal while the case is being prosecuted. I know that's quite a bit. Let me know if you need a reminder of any of those throughout.
So I can answer the first about no contact, and then maybe Tara wants to answer about cost of care. So the requirement of dog and cat in the case is only the requirement to trigger the appointment. But once we're involved in a case, if the court issues a no contact order or no possession order, or no, I mean, we have all different variations. We've no living with, no working with, no sole contact with. But if a court orders that, it usually orders it for any animal. And so that is an expansive order that would apply to restricting contact with farm animals or other kinds of animals, not just dogs and cats.
And sorry, could you repeat what was the question about cost of care?
Just whether or not the defendant is required to pay for the cost of care while the case is prosecuted.
So, and that could just be something that's recommended. And even if we typically report what the full costs are, just so that the court is aware what the costs are to the community, but that doesn't necessarily mean that we would recommend that they pay it. And whatever our recommendation is, the court will order whatever they think is reasonable. So if there is a public defender or assigned counsel, if there's concerns about their ability to pay, the court will only order something that they find is, is reasonable under the circumstances.
Great, thank you. We are at time, but one last question that I think would be helpful for everyone. When will the paper with the stats included in the presentation be published, and where will it be available?
So it'll be in the Quinnipiac Law Review sometime, I don't know, Tara, within the next week?
Yeah, hopefully within the next couple of weeks, yeah.
Wonderful, thanks. Okay, well, thank you everyone for joining us.